All right. Thank you so much for continuing with us here in Morning at NTV Friday's edition. Of course, we must have the discussions for the day. The week has been marred by the case of Dr. Kizza Besigye right from the beginning of it, where you do have a denial of a practicing license to Martha Karua, who is on his defense team. And then as the week went by, you did have different people responding to the situation, the latest being the President of the Republic of Uganda, President Museveni, who yesterday did come up with a letter in which he declared his support for the trial of civilians in the court-martial, recognizing its role in addressing gun-related crimes. And of course, many from the law fraternity have since then faulted President Museveni for contradicting the rule of the Supreme Court on the subordinacy of the court-martial to civilian courts. We definitely must hear all sides in this response to the latter. What does it mean, not just in regards to law, but also what does it mean to you as the Ugandan out there? Because today it's Dr. Kizza Besigye, tomorrow it could be you. Speaking to us on the matter, we do have the Uganda Law Society President, and that is Mr. Isaac Ssemakadde, joining us to give us his own reflections as one that is of legal leadership. Good morning to you. Very good. Let's start off with the President's letter. I know that you've been quoted here and there, but we'd like to hear from the horse's mouth what your reflections are on the President's letter regarding, trial of civilians in court-martials.
The President's letter was, with great respect, ill-advised. It offended the rule of sub judice. That is that where there is a pending decision of the court, comments that may appear to preempt the decision of the court should be discouraged. The President has the most privileged pulpit of all, the presidential pulpit, and it should be used among others to promote respect not only for court orders but also for court processes. So the President's letter was very depressing and disappointing to read, insofar as it failed to acknowledge the existence of an excruciatingly over-delayed judgment of the Supreme Court in the appeal case of Attorney General versus Michael Kabaziguruka, a civilian who challenged his trial before this court-martial and won in the Constitutional Court 4 years ago. It also disregarded 2 other decisions from the Constitutional Court in which there is no appeal. Reverend Emon Byarugaba versus the Attorney General and Semju versus the Attorney General. Amon Byarugaba was decided in 2021 and Semju was decided just this year. So, as defenders of the rule of law, we had to make that clear that we welcome the President's engagement on this issue, but it should be holistic. The President should respect the existence of judicial verdicts and judicial processes against his position.
Okay. As one who's banging the tables, what does this speak into the relationship between the executive and the judiciary as far as the independence of justice is concerned?
It probably speaks to a happy hour. The President's letter depicted panic. The President should be aware, ought to be aware, and I'm sure he is aware, that the Constitutional Court has been consistent, in saying that civilians will not be tried by any further. That dog won't hunt. The military courts have run out of track. The people of Uganda have rejected civilian trials. The courts have accepted that this mistake, which was done in 2005, cannot be continued. There's no argument that can be made. It's now clear. The initial decisions were not as clear as the most recent decisions. The most recent decisions are clear. That's a tribunal for serving officers only. It's a disciplinary tribunal for the military. The courage at the bench has grown, and more judicial officers acknowledging a separation of powers, not only between those three branches, but also a separation between the civilian authority and the military authority, and the subordination of the latter before the former. The military is separate from the civilian authority, and the military is subordinate and subservient to the civilian authority. All power belongs to the people, not to the military, and the military cannot subvert that relationship if we want peace, order, security, and justice.
Of course, the president is making this defense on the account that it's through this that there's been sustainability of peace in the country. But that regarding, you've talked about power being for the people and to the people. In this letter, what should the people actually read in between the lines? What should the translations actually reflect?
The people
for them?
should read into this presidential awareness that defense of the civilian trials in the military courts needed a presidential input. It has lost favor. It has lost rigor. Nobody else can defend this, so the president has to come and do it himself. And he's doing it at the 11th hour, when we have a decision of the Supreme Court we are waiting for any time now. So that is suspicious. And I am an incorrigible optimist. I would like to believe that the president knows. He is trying perhaps to win back one or two judges, but he knows the result. It's only a matter of time that Ugandans will rejoice the end of this fallacy, this tragedy, really. You know, the arguments the president is summoning are the same arguments Idi Amin summoned. They called it Kondo. You know, when there was this coup, 1971 coup, yeah, there was a breakdown in order, you know. And Idi Amin had this master stroke. It then appeared to say, you know, we can fight gun crime by using our military tribunals to take on civilians. And the judiciary at the time said, well, it breaches, you know, fundamental principles of rule of law, due process, you know. It undermines the judiciary. But they crafted some kind of instrument similar to what we have now, saying that the army will take, you know, will encroach on the authority of civilian courts minimally for gun crime, you know, for Kondo, for armed robbery, and so on and so forth, for a short time. It was supposed to be a short time until we've established order, then the courts can deal with it.
Short time has taken 30 years.
Well, the short time ended, actually, I mean, was fair. But it was only revived by the NRM in 2005. They channeled the same reasons. And for them, they didn't do short time. They want to make it permanent. So, but I think military trials have been on display for 20 years now. And so people have a body of evidence. I would like here to acknowledge Dr. Ronald Nalwairo and the Makerere University Human Rights and Peace Center, who have done extensive study of the court-martial system in Uganda. And so the evidence is available. The court-martial system, its composition, its operationalization, its oversight systems, they just don't pass constitutional muster.
Right. Okay. Now, in that regard, let's look into the precedents that are being set by what has happened with the case of Dr. Kizza Besigye, especially for political figures, given the fact that in the next 365 days, that is going to be the talk of time. We're going to elections, the campaigns are about to start, and so different political heads are definitely going to be saying some things that will not be, you know, pleasant to the ruling government, and perhaps they may end up in the same situation. What are the next negative precedences could this situation be presenting us?
Well, the most significant is the role played by courts in politics of a country. The Supreme Court's delay to issue its judgment in the Kabaziguruka case has now become a political weapon in the hands of those who wish to continue repressing political opponents through the civilian courts. So the judiciary has wittingly or unwittingly taken on a political baton by failing to perform its core duty, which is to render justice promptly without delay. So if the judiciary has made delay a system of delivery, it has therefore brought itself into the political terrain, and I do expect that it will suffer huge brand damage in the forthcoming days if this delay continues. The Chief Justice has his goose cooked, plain and simple. I don't think many people see him as a Chief Justice anymore. There is some limited goodwill he's left with, but I don't think if we don't have that judgment before Christmas, he will be seen as a Chief Justice. He will be seen as a political player, and he will be fair ground for all politicians. Yeah.
Okay.
He will be seen as an active politician, and that will do massive damage to the institution of the Supreme Court and the judiciary as well.
What other precedents should be expected with this?
The rest are irrelevant. People can comment about them.
Okay.
Mine is to
All right, let's talk about the general state
rule
of the rule of law in this country, and how exactly the radical new bar has, through your leadership, put out strides to improve this by and large.
Well, the radical new bar has shown people that it can act through executive orders. Our first executive order, number 1, expelled the Attorney General and the Solicitor General from our governing council. We removed a boot which had been on the neck of the elected leaders of the Uganda Law Society since 1956. Now we have freedom to breathe inside council, to think radically if we want to, and to speak exactly what our and to speak to our mandate without fear and obstruction by listening posts and observation posts. They are fighting us, but this time they are fighting us from outside. They are not within our cabinet. So we have freedom of thought, freedom of aspirations within council. That's safeguarded. I guess that's a campaign promise fulfilled, that we would decolonize the bar and democratize the bar. There are no unelected officials in our council now. They don't wield power. We expelled them. We have also brought democracy to the members. As you know, we have called a general meeting, an extraordinary general meeting on December 17th for members to exercise their democratic rights of representation, to choose for the first time ever since 1995, that's 29 years ago, to choose the 2 most accomplished senior lawyers who will represent the Uganda Law Society in the Judicial Service Commission, the important constitutional body that selects judges, magistrates, registrars. All judicial officers in Uganda are selected by this panel of 9. We have 2 representatives in there by law, and previously we didn't know how they sat there. There were deals behind closed doors between different cliques and cabals, and people just went along. But we have radicalized the bar to acknowledge that it's now time for democracy. It's time to bring light into these processes. First of all, internally, within our processes, and then we go and demand these same standards from these, almost moribund institution because nobody knows it. Ugandans do not have a fair judgment of the Judicial Service Commission. You may have listened to the campaigns. The Judicial Service Commission has such poor ratings. It is consistently hiring incompetent judicial officers. It's non-responsive to complaints. It is not on the road daily to perform civic education, a constitutional function it was given. Ugandans don't have a copy of the Constitution in their own languages. They don't have lessons on the Constitution, and because the Judicial Service Commission has never championed this. So it's just a club. It's just a club to, you know, control patronage. And that's absurd. So we hope that we can turn the corner this year through our elections, which are coming up next Tuesday. And that's a campaign promise fulfilled, democratization of the bar. Once that is done, then we will continue, because our executive order number 2, R&B number 2 of 2024, is about a radical surgery of the judiciary. There's a whole raft of aspirations of a better judiciary that lawyers and their clients can articulate and have been able to articulate. We summarized it in our executive order. We can't do much in an executive order. We can only provide an environment. We can only provide an assurance that council will support progressive actions. And we look for the most courageous amongst us to lead the revolution. And I'm happy that lawyers have participated enthusiastically in this process. Yeah, we are also committed to demilitarization of the state, to protecting civilians from repugnant militarism. For instance, trials in civilian courts, in military courts. It has always been the position of the bar. Since 2005, the bar has opposed trials of civilians in military courts. The difference is the magnitude and consistency, all right, of the bar's position. Was it unwavering commitment or not? Yeah, so we are now clear. We call it doctrinally perpendicular. We've had massive introspection during the campaign time. The campaigns that brought me here were very, 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 very hotly contested, and the contestation was on our place as lawyers in society. Have we truly done enough? Can we do more? You know, to correct decades of injustice, decades, so that we can maintain our credibility and visibility and impact in society. So this issue of protecting civilians from what is now accepted as a kangaroo court is priority number 1 for the bar. Lastly, we are also embracing technology, legal tech, for justice. Initially, within ourselves, we're trying to digitalize most of our systems at the bar. Once that is done, then we shall externalize this to the public. There has been some trials, like for instance, our complaint tool, our whistleblowing mechanism that we have already launched. Members of the public are joining, are supporting it, but we don't yet have the resources to publicize this as much as possible. But I'm hopeful that once the focus is done, once we have our leadership core set done, then we shall have a broader range of leaders with whom we can push the digitalization agenda, because digitalizing bar systems without digitalizing judicial systems is half the job done. Okay, all right. You have mentioned that the 17th of December, the extraordinary general meeting that you are having. Is it an outcome of the executive orders? Precisely. Precisely. The office I hold is so powerful for the bar. It directs, the amount of democratization that the bar will enjoy. My predecessors, for some reason, decided that the composition of the Judicial Service Commission is a question which shall be removed from every lawyer and reserved for only, high priests and Freemasons and prima donnas and demigods and godfathers and godmothers, a cabal and cliques, a system, a shadowy, mysterious system. And some people were okay with that. They benefited a lot. But we have had enough of that. We've seen its results. We've seen the harm it has done to legal practice. So we had to show our commitment in writing, and that is the Executive Order R&B number 2, saying that we will hold a general meeting to give every member a chance to have a say in who gets to be on the Judicial Service Commission. And those members will campaign and make a bond with the bar publicly, so that we can hold them accountable to that bond when they join the Judicial Service Commission. They are going there as representatives of the radical new bar to execute our agenda in the Executive Order. And I think they have all committed. They have said they believe in Executive Order number 2 of 2024, and they are in court defending it.
Okay. Speaking of the elections that are coming up, with there's been a bit of contradictions in there. One of the people who was standing for nomination, Fiona Wall, being omitted from that shortlist has caused a lot of dust to rise. But of course, you stand with your ground on your 2 cents in omission of that, her name on the list.
Well, I must make it clear that we have, under our rules, the Uganda Law Society Elections Regulations of 2016, an independent elections committee. So the decision to disqualify, to remove our past president, Fiona Wall, from the saturated list of duly nominated candidates for the post of Uganda Law Society nominee to the Judicial Service Commission was made by the elections committee chaired by a very respected lawyer, Mr. Moses Mwase, and his committee. These are ladies and gentlemen of high moral character and proven integrity. So Ms. Fiona Wall is treading on very thin ice, questioning the integrity of that committee of 5. They have the trust and goodwill of the council and the membership. It's their decision to make, and they made their decision, and it's as clear as day. I think Fiona Wall is not being entirely sincere, and I see it as a case of crocodile tears. But she has put it before court. She will get a decision sometime today, and that will be the end of it.
Okay.
So I reject your characterization of it as some kind of storm. No, it's a storm in a teacup. Okay. No, nobody thinks it's anything. She's simply unqualified.
All right. As we come to the crown of this conversation, Akatalekekas, a few months into your leadership, and everyone was on board up until recently. Some people were dissatisfied with your leadership to the extent of calling you out of office. Where does that situation stand right now? Have you had mitigations and come together to amalgamate the issues that were presented forth?
We're here. We're stable. We are governing the council and running the society. We have the backing of our membership, and that's all that matters. Radical mandates, game-changing, systemic game changers, like executive orders, number 1, number 2, they harm some people. They take away meal cards from privileged Bambis, and they're bound to squeal and cry It's painful. Like children, you take away their toys, take away their, you know, and teach them order. Ask them to grow up. Get out and face the sun. And yeah. So those pockets of resistance have received excessive attention from those who like drama. Yeah. Okay. But that's all it is.
All right.
Cathartic drama.
Okay.
Yeah.
All right.
We have studied on our program, which is called the Radical New Bar Vision 2060. We are making decisions not to please those who are living today, but to provide accountability to those who will come after us 40 years from now. They should be able to say the year 2024 was pivotal to the freedoms we enjoy now.
All right, thank you so much, Isaac Ssemakadde, Uganda Law Society President, who has spoken into the matters of the week and the day, of course, concerning law and order as far as the Republic of Uganda is concerned. This brings us to the end of Morning at NTV, this week's edition. Until we meet again, it's about time we start saying Merry Christmas.